Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular video, we're talking about a Ninth Circuit case that just came out that essentially said that the immigration judge can rely on an admission and from a respondent at the time of the pleadings in order to determine removability. So what this means is that in this particular case, this respondent most likely answered a question from the judge, which essentially said, what crimes did you commit? Or what drug was involved? And the client or respondent answered. And because of that, the respondent was found to be removable. So you never want to admit in immigration court anything about your crimes because it's not your burden. It's the burden of the immigration to show you're removable. It's not your burden to prove that you committed the crime. That's like, going into criminal court and nothing being asked. They look at the defendant and say, "Did you do this crime?" And obviously in the United States they can't do that. So normally what I do when I'm representing a client and the judge says, "Did you commit this crime?" I say, "Your Honor, objection to that," and then I go on to explain that the judge cannot alter the burden of proof by mandating that the client admit or not admit to doing a crime. And then if the judge pushes it and wants the client to answer, I then further object that under the Fifth Amendment, the client will not self-incriminate himself, and then normally the judge will state that it is a quasi-civil proceeding, but the judge cannot make the person answer those questions. So make sure you're careful when you're in removal proceedings and there's questions about crimes.